At first blush, it sounds like a stupid question. Can companies have religious beliefs? But that question has real work implications, and they're behind what could be a landmark case the Supreme Court has to decide whether or not it will take up tomorrow. Hobby Lobby, a crafts chain with religious owners, essentially suing Obamacare at issue, a requirement that would force the company to provide some contraceptive health coverage for employees, even though ownership believes contraceptives run counter to their Christian values. And there's reason to think the court might, in fact, if they take it up, rule for the company. Now, it could, some say, simply extend its own landmark Citizens United ruling, which said the corporations have free speech rights. If that is the case, companies could also be seen to have religious rights as well. Now, the Justice Department, they're against, obviously, any such ruling, writing in a brief, no court has ever found a for-profit company to be a religious organization for purposes of federal law, and that for-profit status is an objective criterion that allows courts to distinguish a secular company from a potentially religious organization. First off, you think they're going to take the case?
I do think they're going to take it because they've shown a willingness to wade into hot rod political issues over the past few years, including Obamacare itself. And more importantly, when the government asks the court to take a case, there's an overwhelming likelihood that they will do so.
Now, before you tell me how you think they will and should rule, make the distinction for our audience between a for-profit and non-for-profit company as it relates to, any grounds for religious objections.
I'm not sure that that distinction is terribly persuasive on the government's part. I think that once you have Citizens United and having a corporation's free speech.
So whether you're Walmart or the Archdiocese in New York, it doesn't make a difference?
Well, the government is saying that historically, religious organizations are treated differently from for-profit corporations. But once you have a holding that a corporation has free speech rights under the First Amendment, there's not really a persuasive justification for holding that they don't have free exercise rights under the same amendment. But that doesn't answer the whole question. Because I think if they take the case, which they will, I think they're likely to extend Citizens United to the religious sphere. But again, that doesn't answer it because nobody has unfettered First Amendment rights. Even in the speech context, you can have reasonable time, place, and manner restrictions on the right to speak. So the real question in the case, it seems to me, assume that they have First Amendment free exercise rights. Then it becomes what standard of constitutional scrutiny is applied to the Obamacare restriction? Strict scrutiny, intermediate scrutiny, narrow scrutiny, it'll be strict scrutiny. And so what do you ask with that? Is there a compelling state interest?
How far would that go? I mean, can they decide to only hire one religion's as employees? Can they decide to only hire married people because single people are up to the devil's work?
Well, that's not what they're going to look at. What they're going to look at is the contraceptive mandate. Is that part of Obamacare? Does it further a compelling state interest? Yes, it does further a compelling state interest. The need that Congress in Obamacare has found to make contraception available for women. So that's a compelling state interest at state expense. Is it narrowly tailored to serve that interest? And that is a problem for the law. Why is it a problem for the law? Because there's tons of other contraceptives available other than the one at issue in the case, and because there's many, many, many exemptions that are granted from Obamacare. So that's where this statute could have a real problem.
Could they then refuse to cover HIV drugs?
If it's the same analysis. It's the same analysis, not on their refusal, but is the law going to survive strict scrutiny, as I've described it?
It just seems at blush, if you start, companies are people, whether people want to acknowledge that or not, it's pretty much established at this point. Mitt Romney got in trouble for saying it, maybe inartfully, but they do. But if you take it where Andrew was going down the line right now, unintended or intended consequences, especially in parts of this country, that could be pretty scary, where you're looking at one line of companies on one side of the street doing certain things and hiring certain people, and the other across the street not choosing to do it again out of religious or whatever other objections. I'm not so sure the general public's really thought this through past contraceptives. It doesn't stop there.
Yeah, and I know Mark knows, anytime you say to a student, you know, businesses, corporations are people, they scratch their head in the same way when Mitt Romney said it publicly, everybody said, is he nuts?
Yeah.
But legally, that's been the standard, and I think Mark is absolutely right. I mean, the question is going to be about this law, and I think they may say it is too broad, and they have to go back and narrowly tailor it. That's what's probably going to happen. So they'll kind of take this middle ground where they'll say, yes, it's a corporation. The law, there's a compelling interest, but it's too broad the way it's written, and they're going to have to narrowly tailor it.
I get less than a minute, but if they have to rewrite the law,
No,
does
just
that,
Not just that part.
well, does it open up?
I want to pick a fight with the whole corporations are people part because, and we don't have anywhere near amount of time for it, but corporations don't think about the future in the same way that people do. People have to live with each other and with their decisions and with this planet for years to come and generations to come. Companies don't. They're looking at quarterly profits and stock
but
prices.
the court is unlikely to go back on
No,
that because they don't go
definitely
back
not.
on
But they
things ever.
should.
They maybe should, but they won't.
Companies should have guilt on their hands too.
Yeah, and I like
Slippery
rainbows
slope.
and unicorns too. But, you know. All right, we're gonna wrap things up right after this.